Thank you, Scott. So Dr. Grace Mallon, who will be our one that we see over Zoom. Dr. Grace Mallon is a Kinder Junior Research Fellow during her postdoc at Oxford's Rothermere American Institute. Her research interests include the history of the U.S. Constitution and government during the period between the American Revolution and the American Civil War. She has been closely involved with the creation of a digital model of the 1787 Constitutional Convention with the Quill Project. Grace, thank you.
Fantastic. Well, I was unmuted. Terrific. Well, I was just saying, welcome everyone to the Let's Examine Grace's Pause in Minute Detail session. And that is an alarmingly large image of my face that you have there. Never mind. I'm terribly pleased to be back in some fashion with the Centre for Constitutional Studies, which is very dear to my heart. And I'm so thrilled to be part of this amazing event. I greatly enjoyed the earlier sessions, and I'm just a little bit embarrassed to be in the company of such tremendous experts on the Reconstruction era. I am not myself an expert on the Reconstruction era, so I'm not going to talk about it, which I hope is all right. Instead, I'm going to focus on the era preceding Reconstruction and try to think about what citizenship might have meant to Americans in the era before the 14th Amendment was drafted and ratified. Now, that might seem like a sort of a funny concern, because what does the 14th Amendment do? It tells us who is a US citizen. And it tells us for the first time who is a US citizen. And who is a US citizen? A US citizen is someone who is born or naturalized in the United States. So that's the first time that US citizenship is actually defined in the constitutional text. But people use the idea of citizenship of the United States and refer to it and designate people as being citizens of the United States or not throughout the period preceding between the American Revolution and the Reconstruction era. So what are we to make of how Americans actually defined and conceptualized and experienced citizenship in the period before the 14th Amendment actually was drafted and ratified? So that's what I'm going to talk about today. And Bradley Ribeiro is a far greater expert on all of these issues than I am. So I'm relying on him to correct anything that I may get wrong in this talk. And I think this question about how people actually experience citizenship, individual Americans experienced and thought about citizenship and how it actually worked in practice, is something that we can also reflect on today, and the different ways that people experience citizenship today. Professor Lash, in his wonderful talk, mentioned the case of Dred Scott versus Sanford. And I'm going to begin there in my talk, not because it's the chronological beginning of the story that I want to tell, but because the arguments made and the opinions expressed during that case posed some very difficult and important questions about what US citizenship actually meant to Americans before the Civil War. So obviously Dred Scott versus Sanford was a sort of crucial case that arose. It was a Supreme Court case that arose out of a freedom suit by a Black man from Missouri. His name was Dred Scott, and he argued that he was in fact a free man because he had traveled and lived in a free state. And so there were a lot of arguments and questions that were being posed during that case about, what is Congress's right to govern slavery in the territories, which we've already heard plenty about. But the Chief Justice of the United States, Roger Taney, took it even beyond that question about whether Dred Scott was a free man or whether his sojourn in Illinois, his time in a free state, made him a free man, and how that might have affected Congress's right to regulate slavery in the territories. He wanted to solve a whole raft of other political issues through his judgment in this case. And he ended up making some rather troubling but rather interesting arguments about US citizenship in the process. For our purposes, the most important of these is his ruling that, I quote, "A free Negro of the African race whose ancestors were brought to this country and sold as slaves is not a citizen within the meaning of the Constitution of the United States." As a result, regardless of whether Dred Scott was a free man, as he claimed, or an enslaved person, he was, I quote, not entitled to sue in a court of the United States. Tawney supported this ruling in the case of Dred Scott with the argument that at the time of the framing and ratification of the US Constitution, no state in the Union had recognized people of African descent as citizens. Therefore, despite the fact that some states might now recognize Black people as citizens, which is to say certain northern states, these people, Black people, did not qualify for national citizenship, which is to say they were not, in the language of the Constitution, guaranteed all privileges and immunities of citizens in the several states, which is one of only a couple of places in the antebellum Constitution where the term citizen is actually used. So they weren't guaranteed those privileges and immunities. The privileges and immunities clause of the Constitution did apply to white people, according to Chief Justice Tawney, because they had been intended to be considered citizens in 1787, but it did not apply to Black people. That was his argument. To follow Tawney's reasoning around who was and was not a national citizen clearly took quite a bit of mental gymnastics. It's not a very easy ruling to follow. It also seemed to be factually inaccurate, as the two justices who dissented in the case, John McLean and Benjamin Robbins Curtis, both argued. In his excoriating response to Chief Justice Tawney, Justice Curtis pointed out that, quote, at the time of the ratification of the Articles of Confederation, the first Constitution of the United States, all free native-born inhabitants of the states of New Hampshire, Massachusetts, New York, New Jersey, and North Carolina, though descended from African slaves, were not only citizens of those states, but such of them as had other necessary qualifications, which is to say being male freeholders or taxpayers or heads of household over the age of about 21, possessed the franchise of electors on equal terms with other citizens. That is to say, not only were Black people citizens in those states, but some Black people in those states even had the right to vote. While this was a powerful point, his colleague, Justice McLean, also noted that for a man to constitute a citizen, quote, it has never been held necessary that he should have the qualifications of an elector. Females and minors, he wrote, were also considered to be citizens for the purposes of suing in federal court, despite the fact that they could not legally vote or hold office. So we have an interesting distinction here. We have a question being posed about whether to be considered a full citizen, you need to possess what we could call political rights, particularly the right to vote. So having the right to vote is obviously very important to American citizens today, but obviously there were a lot of people in the 19th century, particularly women, who didn't have the right to vote. Were they still citizens? And McLean is trying to make that point. A colleague of mine named Derek Litvak, who's currently completing his doctorate at the University of Maryland, studies the question of Black citizenship in the early Republic. And in his work, he makes a very provocative point. He says, we all like to read Curtis's and McLean's dissents in the case of Dred Scott because they feel moral. They're telling a story about equality, about how equality is at the heart of American history and the history of American citizenship. But Litvak also asks, what if Chief Justice Tawney's characterization of the nature of Black rights and citizenship in the early Republic, as dark as it is, was actually closer to the truth? Because what kind of extraordinarily limited definition of citizenship must we have in mind if we believe that Black people, even free Black people, experienced citizenship in the decades before the Civil War? The question that the opinions in Dred Scott posed, that Litvak amplifies in his work, is the question of what we should understand to be the rights that were associated with citizenship in the early Republic before any clear definition of it existed. To support his argument that Black people were not seen as citizens even in northern states at the time of the American founding, Chief Justice Tawney went back into the statute books of the British colonies and the early states to dig up some of the laws that placed Black people, as they would say in the 19th century, under a disability, or that discriminated against them and limited their rights by comparison with white people. Tawney noted, for example, quote, that intermarriages between white persons and Negroes or mulattoes were regarded as unnatural and immoral and punished as crimes, end quote. He added that it didn't matter whether the Black person involved was free or enslaved, quote, this stigma of the deepest degradation was fixed upon the whole race. Beyond this marriage question, Black people faced many other kinds of discriminatory laws and practices in the free North, which waxed and waned in different places at different times across the first half of the 19th century. These included prohibitions on Black children attending public schools and Black people testifying in court in cases involving whites. I think one of the most powerful indications of the difficulties that even free Northern Black people experienced before the Civil War is the limits to their freedom of movement that were widely enforced across the so-called free states. It's particularly striking because when we look at the history of the formation of the US Constitution back in the 1780s, we have to note that establishing freedom of movement of people and goods across the internal borders of the Union was kind of a key feature of the constitutional revolution that took place in that period. We also have to turn once again to that privileges and immunities clause of the Constitution, which suggests that it was supposed to support the freedom of movement across state boundaries. We might also think about your own expectations of American citizenship today. If you were born or naturalized in the United States and considered yourself a good law-abiding citizen, you would be pretty surprised to find yourself faced with some pretty insurmountable legal obstacles to moving from, say, Utah County to Salt Lake County, or from Utah to Nevada, or the like. But those were the kinds of challenges that some 19th century Americans faced. In the 18th and 19th centuries, there existed a network of regulations across different states and localities that were designed to limit the freedom of movement of particular classes of people, whether they'd been born in the United States or not. These regulations were offshoots of an English system dating back at least to the reign of Elizabeth I in the 16th century. This system was called the Poor Law. Because there was no centralized national welfare system in early modern England, local governments were assigned the task of supporting people who, for whatever reason, were unable to financially support themselves. Like today, these local governments and many of their residents did not necessarily approach this task in the spirit of Christian charity. They were particularly concerned about the idea that impoverished people were wandering far away from home and imposing their needs on distant communities. The law therefore provided that people who were unable to make their own living and were not legal dependents, so that's wives or children or servants of someone who could support them, could be removed back to the place they'd originally come from, or where they were considered to be legally settled. So if you moved somewhere away from home and you struggled to find employment, or you lost your job, or you couldn't find wealthy members of the community to vouch for you and support you, you could essentially be deported from one part of the country to another. This legal tradition survived not only a transatlantic crossing in the 17th century, but also the American Revolution and the ratification of the US Constitution in the late 18th century. In the new United States, too, it was understood to be the right of state governments to regulate their own internal police, which is to say the welfare and safety of all their inhabitants, by almost any means necessary. That's a lot of different kinds of powers. State and local governments perceived the poor, people of color, and immigrants as particularly troublesome subgroups whose movements should be closely monitored and regulated. So let's imagine a free Black man living in Virginia in the early 19th century. He's either been free since birth, or perhaps he gained his freedom through manumission or other means. And he's heard that Ohio, where slavery is illegal, is a better place to live as a free Black person than the slave society of Virginia. So he decides to move to Ohio. Before he leaves, he's going to make sure that he has his papers in order. I think this is quite interesting because there's been a lot of talk about papers in relation to vaccination passports and so on. So getting hold of his papers is a bit of a process. It's almost like getting a visa or a passport, and bearing in mind he's only moving within the United States. Our traveler has to visit the county clerk where he lives to get papers certifying his freedom. He then has these papers authenticated by a justice of the peace, who also issues a pass with his name and physical description that will allow him to prove his freedom to slave patrols and other law enforcement officials whose job it is to regulate racial hierarchy in Virginia. When our traveler makes his way up to Ohio, he goes to the clerk of the county where he plans to settle to present his papers. Now, despite the fact that Ohio does not permit slavery, it has laws in place that actively discriminate against African Americans, just as Chief Justice Taney suggested. So Professor Lash mentioned black codes in the period after the Civil War. These are already in existence before the Civil War, and they're in existence in the North as well as in the South, essentially regulating African Americans and discriminating against them as a separate class. In order for our traveler to settle legally in this county in Ohio that he's turned up in, he's going to have to get two local landowners to pledge to pay up to $500, which is a lot of money in the early 19th century, to support him in case he can't find work and becomes a burden on the local welfare infrastructure. In other places, all free Black people would have to carry papers that demonstrated that they were employed by a white person locally, which was supposed to serve a similar purpose. So that's the North. Obviously, in the southern states where slavery dominated both the economy and society, the free movement of free Black people was understood to be a particular threat. Black people traveling from the supposedly liberal North might, given the opportunity, attempt to foment rebellion among the large enslaved populations of these southern states. In 1822, in response to this, South Carolina's state legislature passed a law providing that all free Black sailors passing through the ports of the state were liable to be held in jail between the arrival and departure of their vessels. So bearing in mind, they haven't committed a crime and they are legally free where they come from, but they have to be held in jail while they're in Charleston or in South Carolina. When Charleston officials attempted to enforce the law, it caused uproar among Northern shipmasters traveling with Black mariners. And the situation only escalated when South Carolina attempted to arrest foreign Black mariners, including a Black British sailor. In South Carolina and elsewhere in the South, Black sailors risked being identified as runaway slaves, captured, and sold. The mariners posed a particularly difficult constitutional problem in the early republic. The southern states insisted that because they had the right to regulate their own internal police, and particularly slavery, they should be allowed to control who was and was not afforded the right to come and go at will within their boundaries. They already regulated quarantine for incoming shipping, which limited freedom of movement, and they even regulated foreign immigration, which we'll return to in a moment. So why shouldn't they regulate Black sailors who were traveling into the state? But here's the rub. The federal government had already gestured toward the federal citizenship of Black mariners by issuing them from the 1790s with certificates identifying them as citizens of the United States for the purpose of their interactions with foreign sailors and governments when they were out at sea. And northern states like Massachusetts protested that their own citizens were being discriminated against in an unconstitutional manner because Massachusetts recognized the citizenship of Black people. While the antebellum Congress never acted to curtail the activities of southern states in this regard, the matter generated considerable public controversy, which Kate Macer and Michael Schoepner have both written about quite brilliantly. So the point here is that the free movement of free Black people, along with many of their other civil and political rights, was so restricted and contested that their citizenship was fragile, tenuous, and contingent, even within so-called free states in the North. So too, though not to the same extent, was the citizenship of other people who were considered threatening to the community, especially the poor, whose freedom was also often at risk from similar kinds of laws to those that were used to target free African Americans, especially vagrancy laws. All of this means that before the 14th Amendment, the extent of state and local control meant that people's experiences of citizenship could vary wildly depending on place, race, and class. I also want to touch on the ways in which people's access to citizenship could vary depending on the decision of local authorities. And by people in this case, I mean especially immigrants. Some very fascinating recent work by historians and political scientists has sought to explore how immigration was regulated before the federal government formally took the reins through the 1882 Chinese Exclusion Act. Although the federal government passed laws regulating naturalization, that is the legal process by which an immigrant becomes a citizen, from the 1790s onwards, it did not take over the regulation of who would and would not actually be admitted into the United States until some time after the Civil War. Instead, states regulated immigration, and they regulated it on the basis of the same kinds of concerns that motivated their regulation of free African Americans and their movement. We have to bear in mind, of course, to be naturalized in the United States, you have to live in the United States for a certain amount of time. So immigration regulation is naturally an extension of sort of the regulation of citizenship and who gets to be a citizen. Southern slave societies, for obvious reasons, wanted to retain control of immigration so they could prevent the further influx of free Black people who might bring with them dangerous beliefs about racial equality and Black rights. What's almost more interesting, though, is the case of the northern states and their immigration regulation. Northerners were plenty racist too, as Erica and Kiana have pointed out, but their overriding concern was with the poverty of immigrants and subsidiary issues surrounding the religion and morality of particular immigrant populations. States like New York and Massachusetts passed expansive immigration laws in the 19th century to try and ensure that only the right kind of people would enter their territories and have the opportunity to settle there long term. These laws tried to discourage ships' captains from importing people who might become a public charge, that is, dependent on the public welfare, by holding these captains financially responsible for the immigrants who disembarked their vessels in New York or Boston. The states imposed lengthy periods of quarantine on new immigrants and actually reserved the right to deport migrants to their place of origin if they were found to be sick, mentally or physically disabled, or known or thought to have been dependent on public charity back in Europe, i.e. they'd been unemployed or whatever. Stereotypes about poverty, Catholicism, and alcoholism contributed to the narratives that justified these laws, especially in the case of immigrants from Ireland and Germany. In his book, Expelling the Poor, UC Berkeley historian Hidetaka Hirota shows that, I quote, between the 1830s and the early 1880s, which is to say after the 14th Amendment had been ratified, at least 50,000 people were removed from Massachusetts alone, under the authority not of the federal government, but of the state. In fact, Massachusetts actually deported to Ireland some American citizens of Irish descent because those people were dependent on public charity. So these states made really significant choices about who would have the opportunity to settle in the United States and to become citizens or produce American-born children who would be naturally citizens. They also denied people who were, by any standard, legally citizens of the United States the rights of citizenship by actually removing them to another country. As I've described above, the states also participated in deporting American-born inhabitants to other parts of the country if they became dependent on welfare, and they imposed harsh regulations on free African Americans in the belief that they were more likely than whites to become reliant on public charity. Moreover, these kinds of regulations did not become history with Reconstruction, the end of the Civil War. Vagrancy laws restricting freedom of movement became crucial to Southern efforts to build Jim Crow during and after Reconstruction. States continued to regulate migration even after the Civil War, and the Chinese Exclusion Act was modeled on pre-existing state policies and enforced by state officials. What I want to draw out of all of this is that who would and would not be admitted to citizenship, and who was and was not allowed to enjoy the full extent of the freedoms we might expect American citizenship to offer, was a highly complex and contingent matter in the 19th century, both before and after the ratification of the 14th Amendment. And a lot of that was to do with this question of federalism that Professor Lash mentioned earlier, and that I'm personally very interested in. Not only race and class, but also gender severely affected how people experienced citizenship in this period. While Black people and white people, men and women, all at different times claimed or were claimed to be American citizens, there was a clear and substantial difference in the political and civil rights that this claimed status conferred on each of these categories of American, and where and in what contexts their citizenship would be counted as valid. So place is really important. I think while many of the explicit legal restrictions on rights have fallen away over time, this idea that citizenship is experienced differently depending on things like place, race, class, and gender is still worth considering in our current context. What is fascinating and inspiring, though, to end on a positive note, is that the idea of American citizenship, even though it was really vaguely defined, there was no definition really at all, held so much promise to all these different groups of people in the antebellum period. Having their claims to citizenship accepted, especially with the passage of the 14th Amendment, would become the baseline for further claims about the rights that citizenship should allow them to enjoy in the United States. Thank you all very much for listening, and I'm looking forward to your questions.